Boom. Hey, folks, how's everyone doing? I hope everyone's having a wonderful evening. Hope everything's going well. Oh, we got a fair bit to talk about today. So, and everybody's talking about the second witness, and we got a whole first witness to go through. Now, the first witness might not be all that super momentous, but he's not like, he's sitting there going, I'm not chopped liver. I matter. I matter. So we're going to talk about him too. I hope everyone's doing well. I am just going to go on a little side rant, which is, what is it? Trying to buy a trailer or a fifth wheel is turning into a whole project. It's turning into a whole thing. Because, man, there's not a lot of people who actually answer their ads. So I guess people post ads and then they just forget that they exist. So anyway, that's kind of a side rant. I hope everyone's doing all right. I've got myself some beverages. I've got myself, no snacks. I meant to eat. And then I forgot to have any, and then I forgot to actually do that. So I'm going to also order myself some food at some point. But if you're sitting there going, I hated today in trial, I hated today's trial day, you probably are not alone, because I am betting that I'm betting jurors hated today too. I'm betting jurors really didn't enjoy today all that much. So we'll talk about that because I feel like the jury might have had a rough day. And I don't actually think Brennan did the best job with these witnesses, because I think that these witnesses were super confusing when Lally brought them in, and I think he tried to do better, but I think that it was also still kind of super confusing. So we'll talk about that. We'll talk about some of the moments when they try to make it less confusing, because they still end up pretty confusing overall. We're going to try to sort it all out and try to disentangle it and try to explain what's going on, because that's the whole point of these recaps, is we're going to try to, make things make sense. So let's have a look there. Let's have and Laura and Lawyer wrote a response to the indictments. Somebody's got to send that to me. So, all right, let's jump right in. Let me find our beginning. Let me find the beginning. And I am back to using Court TV's thread, because I don't know why. I was using NBC, and NBC for some reason decided to cut off most of the day's worth of timestamps. So we don't have those. So that was weird. That was weird. All right. So let's get everything set up. I'm always running a little bit to get these things set up. Somebody says, Ian, how are you not into hockey? Because I'm not. Hockey's never filled me with joy, I guess. It's just not something that does it for me. So you don't have to like or dislike hockey, but it's never really worked for me as a thing. All right, so we got that added to stage. We've got me embiggened. I need a current goal. I guess for the current goal, we'll put Chet gets to decide what Runkle eats for dinner. I'm going to put some parameters on it, because there's certain things you don't eat on stream, but yes. All right. Today was also the nerdiest day that we Today was also the nerdiest day of all of the of all the days we had. So and Don't Air is out because I had Don't Air yesterday. So I put the goal there. We got a goal first. When you hit the goal, we'll set up a poll. Yeah. All right. Yes, we're not doing noodles. All right. Yes, everyone could follow the instructions. Okay, here we go. Now, I assume Keefe and O'Keefe have nothing to do with each other, so let's just get that out there. I had some people who were going like, could they be related? And I'm like, I don't see it. Yeah. I don't see it. You guys are not hearing the audio? Oh. Why are you... You can hear my audio, yes? All right, let me try to unmangle the audio. What do you mean you can't hear it? Okay. Everything should be right. 1 second.
When did you first start beginning working as a Massachusetts state?
Okay, sorry about that. Can you hear it now? I hope. I hope you can hear it now. We're figuring this out.
You solemnly swear the evidence you give to the court and jury in the case now and hearing should be truth, the whole truth, and nothing but the
I'm
truth.
sorry, I don't know why it was on the wrong input, but it was on the wrong input.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
Yes,
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes.
When did you first?
His job is to be the police official who's got hair. That is his official job title, is man with hair.
First start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Okay, so he attends homicides, he attends unattended deaths, he attends word YouTube doesn't like, and he also does digital forensic examination. Okay, cool. Let's see what he does here.
Did you have a role in investigating this case?
Yes.
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McKay.
I mean, the thing is that being a cosmetologist, you have standards as compared to this guy.
And Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to Gray Key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, If you take us back to January 29, 2022, were you involved?
So basically, this guy is a gopher. He gets. I turned the audio down a little bit, so hopefully it's balanced out. What is it? So basically, this guy gets sent out, and he goes and picks up the phone, and he connects it to Gray Key. Now, there's going to be a lot of. I'm going to be mildly snarky. Are people saying I'm okay? Why am I too low? I'm turning myself up a little bit. Maybe that'll help. We'll try here, turning everything up. Okay. So, you're going to hear a lot about, the lack of, now people are saying too loud. Okay, great. The lack of a Faraday bag. And the thing is that I don't know that this is the real big thing for a Faraday bag. I don't know that this is the big, that this is a big concern for a Faraday bag, because how do I put this? You want a Faraday bag for situations where you've got like, let's say you are sitting there, there's a guy on the street corner, you arrest him, and, you find 17 baggies, each with a gram of coke in it. He's got a handgun, and he's got a scale, and he's got a, and he's got a, what do you call it? He's got all the stuff that says that the guy's trafficking drugs. So what do you expect when you get into that guy's phone? You expect that when you get into that guy's phone that, in fact, he's probably going to have all sorts of drug trafficking messages, right? And some of those drug trafficking messages might be really useful, because the guy might say something like, he sends a message to his buddy and he says something like, going to Stash House. And then, or he says something like, need a re-up. And then he immediately after that goes and travels from that location to a specific other location. Well, they're probably going to get a warrant for that spot, right? They're going to get a warrant for wherever it is he says he's going to get, a resupply. So, all of these things are important. But what they're really going to want to do is they're going to want to Faraday bag that thing really fast, so that nobody can log into the phone remotely and delete it, right? Oh my God, no one is that stupid. Drug dealers are that stupid. Drug dealers are exactly that stupid. So they Faraday bag that because someone's going to, because the person might delete it. Now, in this case, Jen McCabe has had her phone for forever, like for however long. So if she was going to delete it, they probably would have deleted it right away. But the other thing is, if Jen McCabe logs into her phone and deletes it, that also becomes super suspicious for her. But they should have Faraday bagged it, like it's proper procedure. But I don't think anything happened with the phone that actually suggests that it's a big concern. Hi, dogs. The dogs are there. Yes. Mrs. Runkle has departed, so the dogs are
Involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search, very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence.
He puts evidence in bags. His role in this is basically he sits around He watches other people search for evidence, and he puts evidence in bags. That is his job. He puts the evidence in the bag, and then he signs his name on the bag, and that's everything, right? That is what he does. So yeah. That he's not super exciting in that sense. And stop and shop bags or evidence bags. It's Canton, so it doesn't much matter, right? We've already heard. Those are interchangeable. That's what we heard from the last guy. It doesn't matter what kind of bag you use. Stick it in a stop and shop bag. Stick it in a trash bag. Used or unused. It doesn't matter. No, of course he's using actual evidence bags because yeah. And you might saying, why do you have this guy here? Well, his job is literally just to be part of the continuity thing. This guy's job is to be the central sort of continuity point. Okay. So, we said he put stuff in bags. Here he is with stuff in bags. He's not very good at the removing stuff from bags thing. He's trying. He's trying. Ta-da!
Sir, on those items that are stickers, did you put the stickers on them? Do
I did not.
you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces or is there another piece in that bag?
There's another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off? Do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well?
Okay, little
Is that
tiny baby
smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay. Thank you, Rick.
Okay.
All right, so there's an objection, but then we're going to go over to, we're going to jump ahead a little bit to clear plastic bag. Do you know whose DNA was on that mic you touched before you picked that? Everybody's DNA is on that mic. I just want to say that for cross-contamination purposes, a courtroom is like the worst case scenario for cross-contamination purposes, because literally any person could be in that courtroom, and the number of people who might handle things and the kind of people who might handle things is intense. Why? Because, like, let's say they take a break. Let's say they don't do something that day, and they run like a trial wherein, like, the accused testifies, and the accused is like, a serial killer or something. He's probably not having a one-day trial, but, we're imagining. And it's like, oh, well, now his DNA is on all the things, and then that DNA is now we're getting that on this, and it's like, oh, right. So cops suck at gloves. They should actually get better training with the gloves, because the whole point of this is that you don't get anything on the evidence. And so, like, with the gloves should be stored somewhere sterile, somewhere contamination free, and then they should be put on carefully in a way that you don't contaminate the exterior of the gloves. And then from there, you should go and, handle the evidence in a way that you touch nothing else. Nothing else. What? I saw an attorney stick her finger in an evidence bag full of cocaine and rub it on her teeth in front of the judge, the deputies, everyone but the jury. Oh, if I was the judge, I would have had some thoughts about that. And those thoughts would have been, you don't get to be an attorney in my courtroom anymore. So, yeah. Anyway, this guy's job is put things in bags.
Ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. You recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
There's no objection, Mr. Unity?
There's no objection.
679.
With the court's permission, could we show exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
Once again, he gets to do arts and crafts.
Are these different in color than the last pieces you showed?
Yes.
With the court's permission?
Yeah, the other thing is they keep pulling these gloves out of their pocket. It's like, do you have gloves with you? And the guy's like, yep. And they pull it out of their pocket. And it's like, what else have you had in your pocket? Because pockets are the opposite of sterile procedure, right? I don't know what grows if you pull something out of your pocket and tap it on an agar plate, but I'm guessing it's not. I'm guessing it's pretty funky.
Could the trooper show these pieces?
Yes.
Ta-da!
Thank you, trooper.
Agar? It's for growing bacteria? Okay. All right. So, exciting times. Cool. All right, let's jump ahead to
Again, if you read that silently to yourself and look up at me when you're done.
agar plates or petri dish, they're not super different, no. But I mean, there's lots of different things that you can. Agar is one particular growth medium, but you can have different growth mediums. So the petri dish is the dish. The goo in the petri dish is usually agar, but it can be other things. So, yeah.
Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said Waterfall. Is that the C.F. McCarthy's there, or is that Waterfall?
This is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes. Again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the waterfall barring,
He's like, I don't want to be here. Like, he's like, this is supposed to be my day off, right? He's he's like, this is supposed to be my day off. I'm not supposed to even be here. And he's like, leave me out of this. The thing is that the Commonwealth seems to be going with a very definitive strategy. And the definitive strategy can be described as this: hide Michael Proctor under a rock. They want to hide him under a rock as long as possible, because basically what they're hoping to do is they're hoping to prove their case in the minds of the jury, to have the jury like super convinced that she's guilty before Proctor gets up on the stand. I mean, Proctor's going to have to come in here, but they want the jury already thinking she's guilty, and then they could be like, well, Proctor's awful, but who cares, right? So they're very, very much going to be like, Proctor is gonna be. So the defense keeps bringing up Proctor, but I wonder if that isn't backfiring a little bit, because the jury's gotta be. This is like foreshadowing in a movie, right? You ever been and you go and you watch a really good horror movie, and they don't really do these much anymore, but like the horror movies where they don't go and show you the monster in the first like 8 seconds. And so instead you're seeing like, guy goes into a shed and then there's like screaming sounds and they go into the shed and the person is torn apart, but you don't actually get to see the monster right away. Maybe you don't see the monster until near the end, but until you see the monster, you're like, I want to see the monster, right? And the more they don't show you the monster, the more you're like, I want to see the monster, right? I want to see what's going on. And so as they go through, they're like, okay, like where, and they're making Proctor into the monster. And the jury is like, when do we get to see the monster? And then, of course, the question becomes, does the monster live up to the lead up? Because we've all had some movies that were where they did. I see people in the chat talking about the original Alien. The original Alien lives up to the hype. I've also seen movies where they don't. I saw somebody in the chat mentioning M. Night Shyamalan. His movies never live up to the hype. So I've just pissed off some of the people so yeah. So, was it? I worked on the last horror film I could think of like that, Leprechaun Origins. It's a terrible movie. I can't imagine any of the Leprechauns movies were solid. So, but yeah, if they make Proctor into the big sort of, when do we see this? They might actually be hyping him up for when he comes up there. So, we'll have to see, but I don't know. I'm wondering if this is a little bit of yeah. All right. So
Medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a...
So here, the defense is getting these injuries in. How does he get these cuts above his, because like 2 black eyes and a cut above his, like that sounds like a dude who lost a fight, doesn't it? That's the defense's argument here is defense lost a fight. John O'Keefe lost a fight.
small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. I may have a moment. May I approach, Your Honor?
You want this one back?
Oh, please, thank you. So I placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
That was this is a minor oops by Yannetti right here. Minor oops. He says, having read all that, is your memory refreshed? And he says, yes. And what he should have done is he should have asked the question of, and did you see the abrasion? You got to ask the follow-up question, because now that answer's not actually technically in evidence.
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
This guy's also well-trained, because when he hears the objection, he immediately stops answering the question, which is what you want out of your witness. And Brentwood Chic, we have more green in the chat. Thank you for the 20 gifted memberships, helping get some more green into the chat. We certainly like the green in the chat. So, yeah.
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Gotcha.
You knew when you left that Dr. Scorti-Bello had seen the scratches
They're going to get that cause of death in through Scorti-Bello, I'm sure.
or bites or injuries to John O'Keefe's arms, correct?
Gotcha.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Got to the line of question.
Sustained.
Yannetti knows that this line of questioning is objectionable because it's all, you knew that the doctor found this stuff, right? You knew he knows it's objectionable, but Yannetti also knows that jurors hear it and that the jury is going to, they're going to put all of that into their, information pile. So he gets what he needs on that.
May we approach?
Okay. Jurors, feel free to stand up.
It is easy being green. All right. Now I got to set up, we hit a goal. So I've got to set up a poll. All right. So we're going to abide by poll results. What should Runkle eat? Option number 1, burrito. Option number 2, let's see. I got to pick things that are not going to be, we're not doing pasta because that's just not going to work. Doesn't work well on a stream. Option 2, we will put for sushi. I'm just looking at what my other options are. We're not doing anything sort of slurpy or, or that. I already had donair, so we're not doing that. Chat, do you have suggestions? Do we have suggestions? Chicken wings. Maybe chicken wings are a little too messy. I don't have a good fish and chips place. Not a good fish and chips place, I'm afraid. What is it? Tim's isn't even food. We're not doing Tim's. That's not food. Let's just see here. Turkey and scrambled eggs. You guys have some interesting notions. Do I have Korean that I can order? I see people saying Korean. Yeah, I can put Korean. We can do Korean on this. Pho is too slurpy. Gummy bears. Yeah, I could do dim sum. I see a dim sum option that gets us out to 4. All right. Boom. We got our poll. And we're off. I should have set a timer on it, but yeah. Okay, so let's
What are your concerns about
Input, is it not?
It's not input.
Okay. Did you talk to Dr. Scortibello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, not thank you.
All right, you're all set.
Thank you.
So, jurors, this break you're going to take now?
I love cooking at home. The problem is that I don't have time when I'm doing these things because when I'm doing these streams, I do not have the time to properly cook something. I get off work and I have to do a little bit of other stuff and then I'm back onto this. So I got a 20-minute nap in between this. There was not really time to do a proper meal.
Lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, it's a little bit earlier, but we did get coffee for you, so we'll take a recess now for the next hour.
The judge talking to the jurors is like, we're taking a little bit longer. We're taking a little bit of a break. We're taking a little bit of a, but we got you coffee. Do I have an Instant Pot? Yes, but the seal is not, I need to replace the seal on my Instant Pot. So, I got to fix that. So, yeah.
All right, so please. Let's go with follow me.
Short break while jury exits. Thank you, Court TV. Okay, so we're going to watch this because this is a whole entertaining little argument and we're going to discuss it.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent.
We gotta go back a little further here. All right, let's see what he has to say.
Dr. Hyde, but
Okay, we're gonna watch this. This is important, and this can I just say how much I screamed at this? I didn't watch. I wanted to go back. If I had the time, I was going to go back and watch other commentators like, Emily and Andrea and so forth. I was going to go back and watch their reactions to this part because I wanted to see if they were screaming as much as I was screaming at all of this. It was bizarre to me. So, yeah, we're just going to 1.25, but I have some serious opinions on this.
So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified.
I don't know if she's Dr. Hyde. Is there a Mr. Jekyll out there? Is there a Mr. Jekyll out there?
Testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall.
It's an SJC case, so yes.
Yes. Okay. So now to the Maryland case. So that's governed by Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, a court is a judicial proceedings of a court of another state or of the United States shall be competent evidence in this Commonwealth.
All right, let's just talk about the magic word here. Shall. Why? Like, let's listen to this again because he emphasizes the hell out of the word.
Proceedings, and of course, a court is a judicial proceedings of a court of another state or of the United States shall be competent evidence in this Commonwealth. If
all right, why does he go shall as loudly? Well, because shall is a magic word in drafting. Shall means it's gonna happen. Shall means mandatory. Mandatory. Must happen. So, as an example, if you commit certain crimes in Canada, they shall ban you from having guns. It doesn't matter if they think it's unfair. It doesn't matter if they think that you shouldn't under whatever circumstances. Shall is mandatory. It means that the judge must do the thing. So, in this case, shall be admitted into evidence. It must happen. This is the point where Alessi theoretically should be able to sit down. May means it's up to discretion. It's up to, it's up to determination. Like that the judge gets to make a call as to what's going on. Shall means, judge, you don't get a decision. You don't get any call on this. And so when Alessi is emphasizing shall, it's because it means, judge, you don't get to make a call. It shall be admitted into evidence.
authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
Why does it have to be certified? Because they don't just let you print one out and bring in a photocopy, right? So it's like, yep. Now, at this point, this hearing, like this little mini hearing, should be done. It should be over. Because she should just say, Brennan, I've heard shall. Do you disagree that's the law? And if so, then, yeah.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So
So basically, the argument is the next section says that that something has to be material. This doesn't. Now, relevance is always a part of the admissibility, element for this, but the thing is it is 100% relevant to impeaching an expert as to whether their evidence has been rejected by a court before. On any point, right? If you're testifying as an expert and a court on any point has said your evidence is dog shit, then that is relevant to you testifying, right? Guys, I'm not picking up.
Rule new.
I'm not going to argue with any other commentator who's not here on this one. So,
how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it one
The decision.
Right. Oh, yeah.
But here's the thing. Once somebody testifies to something that is not reliable, right? Then that is relevant to everything, right? Your evidence is unreliable. If an expert is willing to give shit evidence on something, then it means that their evidence might be shit on other things too, right? This is one of the things I've said about the risk of being an expert, is that an expert, anytime they get up to testify, potentially is putting their entire career on the line because, theoretically, if their evidence is awful, that can end their career, right? That can be the end of it because the judge can rule, hey, your evidence is garbage, and then that's going to end up potentially imperiling their ability to testify in any proceeding ever. But not in Judge Bev's court. Judge Bev's court is, it's got special rules. I am just like, okay. So now here's the fun thing. Alessi says, I don't intend to preclude her from testifying. I just want to cross-examine. And when he says that, he means it, because he doesn't say, listen, I want to preclude her from testifying, or I don't want to preclude her from testifying, but then proceeds to argue exclusion. Like, he doesn't do that the way Hank does. Because when Hank says, I don't want to preclude this witness from testifying, all of his arguments are then towards exclusion. In this case, Alessi says, I don't want to preclude her from testifying. I just want to cross-examine. And all of the everything he says is towards, I just want to be able to impeach this witness. I just want to be able to say, isn't it true that the techniques you are using are ones that have been rejected in another court, that you have testified about these things, and it's awful.
What's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking.
Yeah, yes, that is exactly what he wants to do. We'll see him try to do it anyway. I saw somebody saying, I never see Victoria George in the courtroom. I believe that's her in the back right there. Is that not her top left right now? So yeah.
If I could
Me to allow.
give you the answer, Your Honor, I will explain it. It's a very short answer.
Okay.
What I want to do is, with regard to her 227 timestamp
Hello, good
and
to have you
her
back.
anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple source.
Not her. I've misidentified. Okay. Fair enough.
code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to
I thought she might have dyed her hair, but yeah.
cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked.
If she's not asked about the 227, then why the fuck is she here? Like, Judge, come on. If she's not asked about that, why don't we just like say, what if a unicorn comes in and starts kicking jurors? Like, you know, what if a leprechaun starts handing out pots of gold? How would that influence this trial? Like, of course she's going to be asked about the 227, Judge. Just like, let's keep the hypothetical slightly plausible, right? And he's like, well, if the Commonwealth doesn't ask about the 227, then we're probably just not going to cross. Because if the Commonwealth doesn't actually ask her a relevant question, then we don't take any issue with her. Like, he's like, okay. Unless he's just like, I don't know. So, yeah.
About the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the
You can malign witnesses, and it is relevant to what she's testifying to because it's prior expert evidence. Prior expert evidence, of course you can malign an expert as to how they testify as an expert, right? Like, it is super relevant. You know, let's imagine another scenario. Let's imagine you get a witness who says, you know, the Commonwealth finds a witness at the last minute and they say, you know, that witness says, I saw Karen Reed do it. I saw she hit him with a sledgehammer and, you know, that explains the missing injuries. You know, this is the real... Okay, great. Well, it would be highly relevant if that witness had been, you know, found to have lied in a trial that happened a month and a half ago, right? Like, that would be super relevant. Super relevant. You know, and sure, it's a different proceeding. You know, oh, well, just because he lied about that other thing doesn't mean he's lying today. But it's super relevant. Like, they're taking issue with how she conducts her investigations in general. So, yeah.
basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis in that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like,
here's the thing. If nobody can testify about it, that doesn't mean she gets to, like, if Apple source code is, you don't get to just go and be like, oh, right, they get to testify about it just because Apple source code isn't available. It's like, that might mean that nobody can testify to it, right? That might mean that nobody is, you know, so he's like, it's owned by Apple. It's like, okay, explain how that matters. No, I haven't ordered dinner yet because I haven't closed the poll. We are going to keep this poll open until we are done this section. So after that, yeah.
Surrogate as a way to try to cheapen her testimony in front of the jury. Here, number one, what he said.
They're allowed to cheapen her testimony in front of the jury. That is literally impeachment. He's like, Your Honor, the defense wants this evidence in order to be able to impeach my witness, and that is so unfair. Why can they impeach the witness? Judge, it's like she wants to defend herself in this murder trial.
Like, I really can't follow him. I don't understand, other than he's trying to draw some
You not understanding is a you problem, dude.
type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was.
I mean, he's like, we didn't have this issue with Mr. Whiffen because Mr. Whiffen wasn't rejected, but yeah.
The 227 timestamp.
No, that was raised, but this
case where specifically the one witness was not, had issues, that, yeah, of course it wasn't, because this case refers to her.
what was problematic in Maryland, the same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor,
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating by cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the state Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And
100%. Like, the jury ultimately gets to decide what weight to put on it. The judge gets to decide if it meets the threshold of admissibility, right? So let's talk about thresholds of admissibility versus weight. So, Daubert and so forth are about admissibility. Is this something that might help the jury? But that doesn't necessarily mean that it's going to have whatever weight. The jury gets to decide on weight. So let us consider a possible witness. We have a witness who says, I saw everything in this robbery, right? I saw the robber and, whatever, it is Bob, because it's always Bob. It's a hypothetical. It's always Bob. So, the witness says, I saw it was Bob. But the defense is like, their testimony should be inadmissible because earlier he said under oath that it was actually Frank. And those two things are contradictory. So the thing is that that testimony is probably admissible because it's relevant. The guy says who did it. But that doesn't necessarily mean that, just because it's relevant doesn't mean that the jury's going to put a whole lot of weight on it. Because when they hear that this guy has said two different people did it, then the jury might be like, So the thing is, we can't use Bob anymore. Fair. I don't mean Alessi. We're going to have to, Rudiger. In this case, the guy can be admissible, but they can still cross-examine on methodology. And this is exactly what the judge has said about other witnesses. When they've asked to exclude Commonwealth witnesses, the the judge has said, well, I'm going to let them in, even though their methodology might be garbage, because you can cross on the methodology. So, okay. I have not seen Thunderbolts. I'm going to try to convince Mrs. Runkle that we need to see Thunderbolts over the weekend as part of date night. So, yeah.
Actually, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got advertised on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
I mean, he's entirely right. He's entirely correct about this. Every time I hear Bob, I hear battery-operated boyfriend. You should be hearing born on board because... and that is a Marathon reference if you are familiar with Marathon.
You can see the plan to dehumanize somebody, daubertized, to use a term.
Oh, fuck off. Daubertized. That's not the same as dehumanized. Just because you used a verb, that doesn't mean that they've been dehumanized. Like, cross-examined is also a verb, and it doesn't dehumanize. Brennan, these arguments are so bullshit, and why the judge is like, why she's sitting there looking at him like he's making a good point, I don't get it.
To suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that,
how does this dehumanize her? How does it dehumanize her in the slightest? Like, what part of saying that her methodology might be flawed dehumanizes her? Oh.
case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis,
but it was an issue with respect to, is it appropriate to use a simulation for an Apple system, which is exactly the issue here.
The expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible. They should be impeached when they go and talk about a totally different issue in forensic data analysis in another case.
Yes, they should be impeached. People like that is pretty common for impeachment. You sucked in one case. I'm gonna argue like
they have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just use the word methodology. Her methodology was questioned in an opinion in a different court.
I'm sorry, Brennan. Now you're throwing out, he just uses the words methodology. You've been doing that in every one of your applications to exclude.
Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence they have that the methodology used in this case is unreliable or improper? They don't have any. In fact,
they're allowed to suggest it to the jury, right? The jury gets to make that decision.
They called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial...
What evidence? The evidence they have is the evidence that shall be admitted, is what the... So, yeah.
The first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is...
No, she's not asking you to. She's just going to reject it anyway.
Parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data stats. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witness has said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how you impeach an expert, that one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Galbraithized anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it.
He's like, this argument is so bullshit that I'm just going to avoid the term if that's what's... But he's frustrated here because this is... What's happening in this case right now is bullshit. It is just straight bullshit.
I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, in any expert that's been deemed that, you get to attack that.
And here's the thing about being deemed not reliable. It means that she was willing to testify to something that the court said she was not reliable about. So it's like, when you open your mouth as an expert, you might say things that are reliable, or you might say things that aren't reliable. And, like, you can't just, that's a big factor for a jury, right? So, yeah.
The Commonwealth believes the case is not relevant. If Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location she has in her PowerPoint she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion.
So she was willing to testify to something that was deemed unreliable.
From a court that she's an unreliable expert, and this is how they're going to distort it. Invoking the Constitution,
We're doing this,
invoking
and then
the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would.
Yeah, that might actually be relevant to a jury. Have you ever tendered a medical diagnosis that the court rejected as unreliable? Well, yes, I have. Let's go into that. Like, that's of course relevant. If a person who does medical diagnosis for a living is providing diagnoses that are deemed by a court to be shit, then yes, that's relevant.
Would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point.
He
This
tries.
has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
The jury gets to decide whether or not she's credible. The jury gets to do that.
One last word. Go ahead.
Thank you, Your Honor. He just said.
Now, you know that, she's going to rule against him. So his last word probably should have just been fuck. But he's going to make a better last word than that.
credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a superior court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it
I agree with Alessi here, but yep.
overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here. And
He's like, even if this was garbage, the standard is shall, judge, shall. So you don't get any discretion here. You don't have any discretion. It's shall.
I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Haack. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
All right. And Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp?
She's asking this again. What if the Commonwealth doesn't get into the 227 timestamp? Your Honor, let's be real. Like, she might as well ask, like, what do you do if Lally decides to start giving you a blowjob mid-trial? Like, it's not going to happen. There's no chance. You know, this is not a thing you need to prepare for. It's like, what is your emergency plan for zombies? It's like, well, there are no zombies going to happen. So, you know, it's like, just judge. You have shall. Like, the shall should make this easy. You just shall to decision. Like, that's easy.
Whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this. If they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
Because if she doesn't get into 227, they're not even going to cross. Like, if she doesn't, they're just going to be like, okay, then we don't care about this witness. The whole point of this witness is the 227. And yeah, okay.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about,
I don't actually know if I'm demonetized on this stream real time, although I might be. You only know real time if you actually are, if you turn on the monetization in advance. Like, if I was running ads right now, which I'm not, this is entirely super chat supported, at this point, then I would be able to tell if I was demonetized. But after the stream ends, I will turn monetization on, and then I will find out if the YouTube gods are mad at me. So yeah.
227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is
So Brennan is like, we are obviously saying 227, right? Obviously.
something that after a defendant expert may or may not testify could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have
I don't know
absolutely no
either.
basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds,
Okay, but then answer my question after your 10 seconds.
but I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision. And it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer.
I mean, if Brennan was allowed, he would literally handcuff the defense. Like, if they let him, I'm sure he would rather have, like, you know, unless he literally cuffed to the table. You know, and he's considering whether the judge will let him get away with it, because this judge lets him get away with everything.
Your question, Your Honor. We are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no.
Why do you need more notice? Judge, it's a 5-letter word. It's shall. You don't need any notice to decide a shall issue. Shall is super easy. Like, shall it, you don't need any notice whatsoever on this. And to give an example of how you need no notice on this whatsoever, so I'm going to tell you a little story time. We're going to venture into story time of Runkle as a very junior training wheels lawyer. So I am there as a training wheels lawyer, and I'm an articling student, so I'm not a full lawyer at this point. And yeah, I'll close the poll at this stage, and then I'll order food. It looks like burrito is a clear winner. But I am the training wheels, like, articling student. And so I go up and I go to speak to this matter in docket court. And the prosecution says, we're applying to revoke this guy's bail. And I went, well, and the judge says, Mr. Runkle, what's your position on this? And I went, I need 5 minutes. Because I was training wheels lawyer. I didn't, like, I'm, you know, an articling student. I'm not like a full lawyer at that point. I don't know what the test is for revoking bail. I'm just like, I don't know. So we stand it down to give me time. I pull up the criminal code and I'm looking at it and I see that the test says shall. And that the preconditions for the shall are there. So I'm like, oh. So we get back in and the prosecutor's like, we're seeking. And I'm like, I agree because it's shall. And then the judge is like, oh, okay, done. And then the prosecutor was like, and we'll consent to new bail. And I was like, yay. But, you know, once I saw the shall, it was super easy. The decision was, this is not a thing I can fight.
No good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
May I ask one quick? May I, Mr. Gray?
I just want to know, is she here?
Yes, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
All right. So this is scheduling stuff. Will she turn into a pumpkin if we have to put this off, right? And ultimately, I mean, I'm sure she'd be fine with getting paid to show up again. So why is it not? Sorry, I'm just trying to see why this is not showing the previews, because the previews are super helpful. I'm trying to do a refresh to see if it'll show proper previews again. So yeah. All right, we're gonna come over to there.
You have joined the meeting as an attendee and will be muted throughout the meeting. The host would like you to unmute your microphone. You can.
All right. I appreciate the time. I appreciate people's patience. So in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So,
all right, let's talk about how much that is bullshit. Let's talk about how that is incredible bullshit. So, that is an interpretation section. That is a section that basically guides the interpretation by saying, listen, this is how. Now, this is used. The interpretation sections are used when something is in doubt, when there is when there's a question of like two separate possible interpretations, right? If there are two possible interpretations, then you can use that to be like, we need one versus the other. But there aren't two possible interpretations here. There is all of one possible interpretation, and that possible interpretation is shall. That is the only possible interpretation. So going to the interpretation section, that does not let you overrule the shall. The shall must prevail. So this decision is some of the worst shit I have ever seen. And I saw people saying, is this appealable? Yes. In my view, this is appealable. Now, the problem with the appeals, of course, is that you have to determine if they're, it's going to be, is this significant? Might the result have changed? Well, I think it's certainly going to be a solid argument on that one. I am just like, this is absolutely bizarre to me. This is absolutely bizarre. And I absolutely lose my mind over this, because I just go, how do we get here, right? How is this something that is actually, being determined? Like, how is this a possible result? I would be furious on this one. Now, I see, what is it? I see the thing here about appeals cost time, they cost money, and they can be a punishment in and of themselves. I mean, I think that because the appeal on this one, I mean, we're talking about a sentence that basically says she dies in prison if she gets convicted. So, yeah, it is. This is bizarre to me. I am mad. I am straight up mad as to what has happened here. And yeah, I just I don't have a good answer. I do not have a good I don't have a good answer for this, other than just at the end of this, I probably argue I think that they're getting to the point where they can try to swing in, and I don't think it's going to be the successful thing. But if I'm the defense, I'm trying to throw in a reasonable apprehension of bias argument on the appeal. And yeah, I would cite this in that. I would absolutely cite this as a basis for there should be like an apprehension of bias. I saw somebody say, I'd love to see you and EDB debate this. We don't have to have a debate. We can disagree. And I don't think either of us is super interested in, having a debate on that one. But yeah. RM says, your hair can tolerate bleach at this age. My hair has not seen bleach. I do not bleach my hair. This is the color my hair is. So, yeah, my hair can tolerate bleach. I doubt it, but I mean, I do not do anything to my hair. Okay. All right. Let's keep going here. So, yeah. EDV said it was fair. We can disagree on that, and that's fine. We can each have different takes. So, how's your hair that silver in your mid-40s? It was going gray. It started going gray pretty seriously when I was like 16. So, yeah. All right, let's jump back in here. I'm also ordering, I'm on Skip the Dishes ordering a burrito.
Bring the jurors in, please.
You are unmuted.
Chrissy, do you want this under that?
I will take cilantro. I will not take jalapenos. How do you grow it so fast? I don't know. It just grows. It just grows. So, yeah. That's all. So, yeah. EDB misunderstood the ruling. She thought Bev split the baby, just not allowing the documented evidence, but that Alessi could cross about it. I mean, it's very clear that she doesn't allow that, because when Alessi tries to cross on it, she shuts him down so hard. I see somebody saying, yeah, if I'm Alessi, I'm pissed off here too. So, jury comes back.
Good afternoon.
All right, I'm going to tell you the one thing we're not doing in this in our analysis here. I've seen some people doing this on Twitter and so forth, and I'm going to tell you what we're not putting up with. We are not criticizing her hair covering, because I don't know what her hair covering is, but I have a very, very strong suspicion that it's religious. And I don't care what her religion is. I don't care what her religion isn't, but we're not mocking that. That's offside. It just doesn't matter. So we're not doing that. That's just not. She's got plenty of stuff to mock that isn't that. So we can comment on other things. So yeah. What is it? Yeah. Somebody, I don't care if it's covering dreads. I don't care if it's whatever. It's just, she's allowed to have hair. She's allowed to have a hair covering. It's all whatever. We're going to talk about the other stuff. Okay, so we got a lot to talk about with her, so we're going to jump right in. Here we go.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University, not Georgetown. But thank you. I also teach...
George Mason versus Georgetown. I'm like, is one better than the other? So, yeah, I don't know.
My company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, etc.
Do you engage in any other type of academic?
All right, chat. I'm hitting the order button, so we have accomplished the last goal. The current goal is Runkle could use a drink, because this makes me want to. This is going to drive me to drink. So, yeah.
Academics or research?
I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer?
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are 3 types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those.
Internet of Things devices is kind of its own scary ass thing, because we're getting into a world where everything is internet connected. Where every single thing is internet connected. And where this becomes a real problem is when we get judges who are like 78 and the judges want to impose conditions on people. So let's say you've got a guy who is accused of sending a threat over the internet. And the threat is something like, the next time I see you, I'm going to punch you in the face, right? The kind of threat that people make on the internet all the time, but it is technically illegal. And so the judge goes, well, this threat was made over the internet, so I'm going to put a condition on this person that says that they cannot possess any device that allows them to connect to the internet. And the problem is that any device that connects to the internet used to mean like just a computer with a, whatever. Now it can mean your light bulbs. It can mean your fridge. It can mean your stove. It almost certainly means your car if you've got a modern car. It can mean all sorts of stupid things. I got a package not long ago. Somebody came to the door, the post office person came to the door and was like, hey, will you sign for this package? And that package, like the sign thing, connects to the internet because it's a little sign pad. Like everything connects to the internet now, and it is absolutely insane. So, yeah, but it's a whole headache and a half. Okay, what is it? When will you show the puppers? I can show puppers. And if you're trying to do business and tell them you can't use devices connected to the internet, they're going to assume you did a certain kind of bad. Yes, they're going to assume it's a bad pictures kind of bad. Yeah.
Computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
So basically, she's listing every certificate she ever got. Okay, but I'm just going to also say, like, a lot of this is not... There's a lot of, there's a certain amount of, like, BSing here, because it's like, all right, so you got all these, like, certificates, but that doesn't mean much here. Yeah.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Wait, you just literally contradicted yourself in the course of this sentence, because you said you're always present for it, and then you said there's one happening right now, and I'm like, which is it? But the thing that really made me go, what? Is that she says, I run an online video course. The number of places that have asked me to do, like, to set up an online video course is lots. And I haven't, because most of these online video courses are not super exciting. So, or not super super good. So yep, we're gonna see some thoughts here.
Forensic data analysis seems like a broad field. Are there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
All right, now we're gonna start in. She's gonna jump right into the main thing she's here for.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, if you think about it, if on your phone you can go to the Google Play Store or the App Store, and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Okay, so basically the argument they're going to be trying to make is she is the smartest person ever, and that the defense expert is basically a moron, and that's the goal here. So yeah, we're gonna jump ahead to no, wait, we're gonna jump a little bit. We're gonna jump to here.
Is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrite, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the...
So the reason why you want tools that don't change the underlying data is because this is a forensic examination. So you really don't want to mess with the stuff you're looking at. So, yeah.
Tools, presentations, and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundations paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search.
Whoop, 1 second. I may have to... Oh man, that was annoying. So the restaurant is out of cilantro lime rice. Can they use brown rice instead? And I'm like, yes, but because it's a telephone person, they're like, we can't get to the point. They're like, hey, I just need to inform you that this call is being, and I'm like, get to the fucking point. I'm like, I'd like the cilantro lime rice. That sounds delicious. But if you don't have that, then just rice, whatever rice. Like, come on. And the guy's like, thank you. And he's got like all of the speeches and whatever else. And I'm just like, just do the thing. I'm busy. Yeah, that was, yeah.
Did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrate.
Okay, I mean, she is being really particular, but yes.
Is there any danger for an untrained eye to rely simply on the soft?
I'm a bit behind. You don't take jalapenos, but you're the hot sauce guy. Jalapenos are not spicy to me. Jalapenos have no spice value as a pepper. I can eat jalapenos like, whatever. The problem is that jalapenos don't taste good. Jalapenos are not spicy. They just taste like shit. They taste kind of soapy. They're one of the least pleasant tasting peppers. And so I don't get jalapenos because they don't actually add the spicing. They just, they just taste soapy. Scotch bonnets aren't bad. Habaneros are not bad. Yeah, like throw some habaneros on there and we'll talk.
Where when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching.
She's like, it's a really scary danger. But the funny thing when she says some of us leave our tabs open forever. Now, I don't have an iPhone. I've got a, what is it? I've got a, what do you call it? An Android phone. But I'm just pulling open my tabs. And there's a section of inactive tabs that I haven't opened for more than 21 days. And the first one is a link to high-profile cases, specifically the Rust trial. And I'm just going to note that first tab is that first tab is from before the Rust trial by a long stretch. So yeah, it's anyway, so she's talking about the really scary dangers, and then we're going to get to some another moment here.
The plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure, like looking at your banking information. You may intentionally...
Ma'am, the industry-supported answer here is maybe you're shopping for Christmas gifts. Everybody knows maybe you're shopping for Christmas gifts means the other thing, but you don't just drop. I mean, she's right, but the, whenever they talk about private browsing, it's always like, what if you're shopping for, Christmas gifts for somebody? The other fun thing on that one is I tried using private browsing to keep Mrs. Runkle from finding the engagement ring I bought her, but it didn't work. But yeah, she's just real
browsing or non-private browsing.
She's just real
so
direct.
Non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure, like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And this.
Now, I'm just going to note, if I was teaching experts how to testify, I would tell them not to use porn as the example for private browsing. Why? Because some of the jurors might judge her. Now, I'm told that this is a very young jury, and so maybe not. But I could see a juror going, well, she said porn, so I'm disregarding everything that she has to say. Because sometimes jurors do all sorts of stupid things. So, yeah. It's just like, she's just like casually like, okay, we're going to just drop out porn here. So, yeah.
Case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question. Yeah.
Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 227.
I mean, this is, I hear people who are like, how do I go into digital forensic, how do we go into digital forensic analysis? And I go, don't. And they're like, why not? Isn't it a great field that pays a whole bunch of money and whatever else? And it's like, you know what you're going to be spending your life doing, right? If you don't want to spend your life looking at stuff that will horrify the hell out of you, don't go into that field. At all. Ever. Full stop. Because, you'll see lots of porn, lots of people's nude whatever. But you'll also see lots of like really horrible porn. And you'll also see, you'll see images of people dying. You'll see images of like all sorts of things. Everything you look at will be, horrific. And, yeah. Just no. All right. We hit a goal. Runkle needs a drink. We are going to yeah, it's I can just say that the police that like end up in those roles, they often last like only a few months in them. Like they'll be like, "Oh, I got assigned to doing like I'm going to catch really bad people." And then they last like 6 months before they burn out and are like, "I never want to do that ever again." It's very much a thing. You get all sorts of all sorts of awful stuff. So yeah, it's a job that is basically a quick route to a little bit of PTSD. So, and Jamie has the best use of incognito. I use incognito when I Google something hella embarrassing, like spelling for real basic words. You're not wrong, but yeah, I'm told I got to grift better. So, yeah, this is the other thing. Was it Twitter or Facebook watchdogs had a high turnover rate because of some of the horrific things they witnessed? If you do anything like moderating and so forth, if you do any sort of moderating of any place where people can post images, you're going to see some horrific stuff. So yeah, I work in a toxic environment. Runkle is my therapy after a long day. Well, I'm glad that I'm helping. One case has a few legal assistants and others rotating the work because it is so awful. That's just legal assistants at one law firm. Recently, Canadian law changed. Canada actually changed the law because of how horrible stuff can be. So, Canadian law restricts jurors from talking about their jury experiences. So, what is it? Mrs. Runkle was on a jury. And when she returned, she can't talk about her jury experience. I don't know what she did on the jury. Like, I don't know what the deliberations were. I don't know anything. Notwithstanding the fact that I'm kind of curious, but we can't. But they changed the law recently to allow jurors to speak to therapists. Because previously the law said it was illegal for a juror to speak to anybody, including a therapist, about it. And so, they'd be like, I want to go to a psychologist in order to talk about, the fucked up crap. And, yeah, that was a recent change in the law. I'm critical of a lot of the things our government has done recently, but that one is a good one. That's a change I go, yes. They should have just said you can talk about it fully, but they didn't go there. So, was she able to tell you what she had to eat on court days? It was basically just cafeteria food. So that she could tell me. And people are asking about the Bud Light. It is their Bud Light Chelada Spicy. So, yeah. Somebody is asking, what is it? Somebody was asking, have I ever been on a jury? And I have never been on a jury. And now I never will. So, yep. All right. Let's keep going here.
40 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair.
I mean, I've got no retirement plan other than I'm going to die. One day I will die, but that is my retirement plan.
Understood. So all of those databases I was just mentioning before, we're looking at all the parse results from all of those. And I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for Browser State DB, Cloud Tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those. And then I was combining them to timeline out the activity.
Here's the thing. She's telling us all of these details. I should just note, this thing doesn't taste at all like Bud Light. It tastes like Clamato. She's telling us all of these details, and it might be like, oh, she sounds smart. But the thing is that none of, like, this could be simplified so much, and the jury would really appreciate it if she simplified this out, right? The jury would really appreciate if she actually boiled this down. So, because sometimes you got experts who really like to sound smart, and they like the feeling of people thinking they're smart, and it just makes you sound confusing. You know how you know when somebody's actually smart? You know somebody's actually smart when they can explain it to somebody who has no grasp of this. And she tries, but not so well.
At 6:23:51, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari list.
Can they appear in different rooms in the databank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CD.
No, what? Like, just say yes. Like, this is a simple question to just be like, yes.
I love that Apple calls that knowledge. It's like what it's trying to learn. So
nobody cares what you love.
With the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 6:20.
Let's go back to the actual question, because the actual question and her answer don't really have anything to do with each other.
Can they appear in different rooms in the databank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And
I'm like, what did that? You lose the question in her answers because she just wants to talk about random stuff. And it's like, just answer the question. Just answer the question, because they're trying to make this clear to the jurors. And your rambling non-answers are not great.
Finally, at 6:24:47, did you identify any artifacts with that search that appears with a timestamp of 2:27:40? Did you find the same?
Correct. At 6:24, we have two timestamps in the same two locations for Hoslong to die in cold, the Knowledge C and the Mobile Safari plist.
So based on...
All right, we're going to jump ahead a little bit to a critical moment here. We're going to do a little bit of jumping because there's sort of a critical thing here.
Three renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions. Is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents, from the community, from the scientific working group digital evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, how's long to die in cold.
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase how's long to die in cold was made at the time of the timestamp 2/27/40?
Judge Cannone, may we approach?
It's the last time Mr. Alessi on this issue, okay?
What? What? What the fuck? Let's go back. And I just want you to listen this. Listen to what the judge says.
Was made at the time of the timestamp 2/27/40.
Judge Cannone, may we approach?
It's the last time Mr. Alessi on this issue, okay?
That's the last time, Mr. Alessi, on this issue. Can I rant about this? I'm sure I can, because this is my channel. And yep, we're gonna rant. I mean, I guess I'll watch the viewer numbers, and if they plummet, then I know I've effed up. But that's the last time, Mr. Alessi, on this issue. This is the judge who said we will not have any like objection hearsay or objection leading, because the jury might hear the word hearsay or leading. And instead you go and you drop, that's the last time, Mr. Alessi, on this issue. Like, I'm sorry, Judge Cannone, you've got to realize that they're probably drafting an argument that, you know, on appeal that alleges that you were biased. And why are you giving them ammunition on this one? Because you should never, ever, as a judge, indicate anything to the jury that indicates you have some sort of negative feeling towards counsel. You have an obligation, and that is unbelievable that you're just like, oh yeah, we're just going to go ahead and do that. Can I just note, you know how much she fucks up? She fucks up so bad, she gives one of the worst, most pathetic, contemptible, curative instructions on this that I have ever seen. It is absolutely pathetic how she does it. And it is absolutely not sufficient. It is absolutely so. Let's have a look at her. We're going to jump ahead because her curative instruction comes at like, this is at like 3 hours and 32 minutes. Her curative instruction is at almost 5 hours in. And so we're going to talk about how her curative instruction is actually kind of dog shit. Is actually like so bad. So let's jump to her little curative instruction. It is so bad. It is so depressingly pathetic. Here we go. 5 hours in, it's an hour and a half after the statement is made that she finally gives a curative instruction. We're zooming. Why is Court TV zooming in on random other reporters? And she made just under 208,000 last year to be this way. Well, it seems to me that she made a poor career decision. She really ought to have been a Canton police officer. Because, yeah. So this...
You are unmuted.
All right, jurors.
All right, so we're going to play this at 1 speed. We've been at 1.25. We're going to play it at 1 speed.
You are unmuted.
All right, jurors. As you know, I think I told you in the beginning, one of my functions is to make sure that a case is tried fairly and efficiently, and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I am, but if I seem to cut somebody short, the lawyers are just doing their job. When they request sidebar conferences, they're just doing their job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job.
Holy... This is not curative. This is an aggravating instruction. This is not curative. And the thing about a curative instruction is it is not your time as the judge to defend yourself, because she's actually defending herself, like she's defensive in this. And so there's no curative anything.
This is to make sure that a case is tried fairly and efficiently, and not to waste anybody's time. So,
oh, my job is to make sure that no one is wasting anybody's time. So when I shit on the defense, it's because they're wasting people's time. I am shitting on the defense because they're time wasters, jury. I want you to know that I am wasting people, that the defense is wasting people's time. So that's how she starts this off.
I get frustrated at lawyers about something. I try not to, and I don't think I am, but if
I try not to, and I don't think I am. Then why the fuck are you doing this?
I seem to cut somebody short, the lawyers are just doing their job.
They're just doing their job, wasting your time, right?
Request sidebar conferences, they're just doing their job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job. Okay.
I also just want to talk a little bit about the just doing their job line. Because where do you hear the just doing their job line? Where does that come up? Is there anyone in history that we talk about how they were, talking about they were just doing their job? Like, it almost sounds like she's applying the Nuremberg defense to the defense team. The lawyers are just following orders. And I'm like, what? Let's talk about how a curative instruction could have looked, how a curative instruction should have looked. Curative instruction might be something like, jury, earlier today I made a comment. You may or may not have noticed it, but it may have come off as a little curt or snippy to counsel. I just want you to know that is not evidence. It's not appropriate. It was my error. And I ask that you disregard it. The counsel has done nothing wrong. There are no, the only person who did something wrong there was myself. So jury, I'm asking you to disregard that. That was my error, and it is not to be used to, to weigh things one way or another. So now I'm hearing doggos, and the doggos are going off because my food has arrived. But yeah, the the just following orders thing is bizarre. I'm getting a motion for pigeon business. We can do pigeon business. I'm also hearing Mrs. Runkle out there, but I'd better go get my food. I will be back in just a second. Where's a good overlay here? I need a good let's see. Okay, enough of that. Let's take down the goose, the goose of delay. All right, so yeah, that drove me nuts. So yeah, let's go back a bit. We're gonna go back to hereabouts. And I'm gonna in Smollen, and here we go.
May I first inquire, you meant morning, as I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train
You
of
have an
thought.
opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6/24/47, House Long to Die in Cold.
Overruled.
Just ensuring that I have the question correct.
Please,
You're asking if what else occurred in that tab prior?
yes.
That I cannot say with a clear degree of certainty.
Did you develop a chalk that I showed you
did.
earlier?
Yes.
Like to approach?
Yes.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I've moved subject to redaction that this be introduced into evidence.
Your Honor, I have no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. Your rights are safe.
Thank you, Your Honor, I appreciate it.
Exhibit 82.
Your rights are saved is basically for appeal. You preserved your rights for appeal. So yeah.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
We're going up to 1.25.
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. High, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29, 2022 on the device under examination.
Now, I just want to say, you're a juror. You're being shown this diagram. You're being told that this will help you understand and you are thinking, what? How is this helpful for me to understand, right? Oh, look, Safari cache record, Apple suggested term. How long does it take to digest food? And you can see the URL, https://cdn2smoot.apple.com, gibberish post.healthline.com, more gibberish. How long does it take to digest food.jpg? Like, are you really getting keen on this particular Excel spreadsheet? Like, okay.
If I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says, how's long to die in cold? How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store how the data is stored, the search term how's long to die in cold, with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
Oh, wow. That's super clear. I understand it so better. It's the NIST OSAC data generation guidelines. Thanks.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record.
Mm-hmm.
What is the term? And what does that mean under the search term?
The cache records, it's cache, not cache.
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy.
And you see how much it annoyed her that he said cache? And she's like, the cache record. The cache record. He's like, no.
Access to when we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long? TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the mobile Safari plist, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that.
Nobody cares the mnemonic you use to teach your students.
Same search. So that search is being tracked in two places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see how's long to die in cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears?
The jury right now, if they were allowed their phones, would be Googling how's long to die in jury booth or in like how's long to die of boredom. I'm seeing motion for goat scream. Where did I put the goat? Goat. Where did I'm not. I set the goat down. Oh, it's behind my drink. There we go.
At the bottom, at 6:24,
Don't worry, though.
47. And
She's going to clear it up, and she's going to make it interesting with this little analogy.
it also appears up at 2:27:40.
As mentioned before, through testing of the artifact for browser state DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold was searched at 6:24:18, tracked in that mobile Safari plist, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for browser state DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 2:27 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the how's long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty of the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that HOS long to die in cold was searched at approximately 6:24 a.m.
Now, moving on from the 2:27 search, there are two other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "how's long to die in cold," was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's
So now
important.
we're gonna
So
get
we'll talk
into
about that in a
some
second. But the
explanation.
first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones.
Does the jury know what an SQLite database is? Have you explained that? Okay.
Actually, one of the most common. When that database stores data, it has two versions. The most recent version and the version in use here uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant.
She's going to try to explain it, and the trying to explain it is awful, but okay.
Written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening.
What? What?
Sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone...
All right, let's try to do this a little bit less crazy, because that explanation, by the time you get to the end of it, I'm like, I don't know where she's going. So let's try to explain what she's saying a little bit, I hope, less confusingly. So when you have a database that's in use, you're not going to write data to and from that database because it's in use. That if you're messing with it while it's in use, that could cause problems. So how do you get around the problem of we need to make changes to this, but it's potentially in use? Well, you have a second file that is just a list of all the changes you want to make. So while that file is in use, you use the second file, and it just is a to-do list of all the things you have to do as soon as you can once that database is available to write. So when the database gets closed, they look over to the to-do list, your write-ahead log, and they do all those things to the database. And then, they can clear that out. We don't need pizza. We don't need waffles. We don't need, anything. It's just like a to-do list for what you're going to do to the database log or to the database as soon as you can write it when it's not screwing up. 2 minutes, and you don't need to be like, that's a deletion, right? I mean, people know what a deletion is. Yeah, I don't know. It's I found that her explanation actually made it more confusing, not less confusing. And by the time you get to the end of her explanation, you're like, I don't know what this is about anymore. So yeah, I don't know. And I found her explanation just a little bit kind of insulting because people understand technology basics, right? They understand some of the issues. And somebody says ChatGPT gave me a bank teller example. Sure, we could do it as a bank teller example. We have a vault. The vault is only able to be opened at certain times, but you still have to do transactions in the meantime. So you make a list of money to go into the vault, money to come out of the vault. You have that list. And then when the vault opens, you do all the transactions and then you close the vault again. The to-do list of all of the things that you want to do when the vault opens is your wall file. All right.
Is imaged. When we make a forensic image, the applications are still open, so we have those wall files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table yet. So when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So
what? At this point, I am so deep into the gibberish that I'm like, I don't follow your anything. So,
when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database.
Wait, the wall file can contain food?
So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section.
Oh, really? The peer-reviewed paper that I mentioned earlier that I had accepted in... No. This is not the time. She's like, let me just drop my CV here and just leave it for you. Okay. Yeah. I don't get it. So yeah.
that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the WAL file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the WAL file. That particular item and it's a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Ha's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that.
So she needs to stop rambling and start answering the questions that she's asked. And if the lawyer thinks that there needs to be more explanation on a point, then he can ask for it, right? So, yeah.
There are, as I mentioned, other carved from the database, from the WAL file, elements such as the search for the YouTube video, It's Raining Men. Because at some point that was the last viewed item in a tab when that tab was retired.
And then I tied an onion on my belt because it was the fashion at the time. Like, yeah, okay. Okay.
Right before, also at 2:27 a.m., but a couple of seconds before the Ha's long to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the WAL file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the WAL file for that reason. It doesn't indicate it's deleted. The second reason is there is no...
Oh my God. Do you know how much it hurt me when she gets to the second reason? I'm like, oh my God, that entire explanation is only half of her answer? Fuck. I feel like you could die of frostbite listening to her like explain the directions to like
user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So
what happens though if you happen to know some tech experts? Like, say, if your husband happens to be a tech expert, or if you happen to know tech experts in the Canton Police Department, could they, for instance, go through and delete a tab? Because I know they can. The hex editors that she's talking about, I have used those hex editors to get around problems with these things, and... yeah, I'm like, because the thing that made me think was, I am like, okay, a user couldn't, it requires a little bit more work. I would have asked the question of, a user couldn't delete it. Could you delete it? Do you know that? Like, you could do it. Runkle is listening to this the second time. I'm listening to this probably a third time because I had to go over, I had to go and re-timestamp a bunch of things because, yeah, so, yeah, I know people are noting Matt McCabe is apparently a CEO of a tech company, so, yeah.
it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you look...
But the software you noted would allow you to do it, like the hex editors. So, yeah.
Looked at the software, whether it was Axiom or Celebrite.
Yeah, if you're using an SQLite, you can tweak things. You can edit some of those things. So, I wonder what her score on Rate My Professor is if she has one. Her score is actually just pi, like 600 digits of pi. Yeah, because, you know, it's long and rambling and also a mediocre score. Okay, that's enough of that. We've sort of gotten to where she was testifying, so we're gonna go to the beginning of the cross here. Here we go.
And efficiently, and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I can, but if I seem to cut somebody short.
Higgins's game score is, it's like an anti-score.
The lawyers are just doing their job. When they request sidebar conferences, they're just doing their job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job.
So pretty close to pi.
Go ahead, Mr. Leslie, if you need a witness.
I just need a witness. Yes. Certainly.
Great, good afternoon.
Afternoon, Your Honor.
May I, Your Honor?
Yes.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first one. I apologize. This is the one, I believe it's May. I don't remember the
May
date
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously.
You see what he did there? This is Alessi. This is Alessi just casually saying, I know your case better than you do. He just casually is like, yep.
This is the one, I believe it's May. I don't remember the
May
date
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20. Yes, that's correct. Very nice. Then I have the third.
You see how she's a little rattled by, and yeah, we can slow it down to one. She's a little rattled by him getting there before she can. And she's also a little condescending. You can see that she's starting to throw some attitude.
2024?
December 20. Yes, that's correct. Very nice. Then I have the.
Very nice. Okay. All right. That's how we're going to roll, is it? All right.
The third one, this is the final one regarding the phone that was identified as Miss McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that.
And she's like, if we don't need that, that's fine, because she's already been told that that's been shut down. So, yeah.
In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard,
So he tries to cross-examine on this, and the judge is like, nope, you cannot mention this at all. Not at all. Like, you cannot.
do you recall another case from the state of Massachusetts, Arrington case,
in which you submitted a pro se amicus. Do you recall that case?
I do.
And is it correct that in that case you submitted?
He didn't get permission. I don't know where you're saying he got permission to cross-examine on that. The judge said no. The judge excluded that case. So I don't know where are you guys getting that she said. Where are you guys getting that she said he could? The judge ruled that that case was excluded. So no, he was not told he could question her about it. That case was excluded. That was not the judge said that case is not coming in. Right. She said it couldn't come in as evidence, but that he could cross-examine her. But she excluded the case. He's cross-examining her, but the case was excluded. He can't mention the case because it was excluded. She didn't say that he could cross-examine on it. She said the case was excluded. So, yeah. She can cross on the methodology. Like, the methodology outside of the case. That's it. So, yeah.
Arguments on behalf of the prosecution in that case?
I submitted an amicus brief.
He did not. No, this is not the ruling. This is not the ruling at all. The ruling isn't that he could cross her on it. The ruling was that he could cross her on her methodology, not on the case. The Herrera case was absolutely like out. So, yeah. That's why the judge is like, nope.
Which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that quote, friends of the court brief, correct?
Took a position on the evidence.
Right.
All right. So we, I guess, have to go back here. We are at 5 right now. We're going to go back to, the ruling. We're going to rehear the ruling.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Please be seated. Court is in session.
The host would like you to unmute your microphone. You can.
All right. I appreciate the time. I appreciate people's patience. So in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly where offered without notice to
the Maryland decision is Herrera. That's the one that he tries to ask her about and that he gets shut down on. That's the Herrera case.
The court previously. I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that.
So what she says is, I'm excluding that decision. She's excluding Herrera entirely. And when she says your rights are saved, Mr. Alessi, what she means is you fought over this. You can appeal this decision. You know, you have saved this for appeal. You have fought this issue. You know, it's not, I understand you haven't waived this issue, but like the Herrera decision is excluded. She's clear on that.
Decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision.
When she says you are free to cross-examine Ms. Hyde regarding her methodology, it's not using the Herrera. You can just cross-examine about whether her methodology is crap, but they cannot use Herrera. So just to clear it up, that's why he gets shut down hard. That's why he gets shut down hard. Runkle, do you think her decision is fair? No, I think her decision is flagrantly wrong. Flagrantly wrong. So, yeah. All right. Why did he start with it? To see if he could get away with it. To see if he could argue that the door was open. To see... and also, I think he started with it in order to show an appellate court that he would have argued it, that he was going to rely on Herrera. So I think some of that is padding for the appeal. So yeah. What is it? It's flagrantly wrong, meaning it stinks. Yep. I think he did that for the appeal, just to say on appeal, he can be like, I was gonna ask about Herrera. I was gonna ask. EDB misunderstood it, so maybe Alessi did too. I don't think Alessi did, because if he did, he would have gone up to sidebar. I think he was doing it tactically. Serious debate question: what toppings belong in a pizza? Anchovies, but not pineapple. Need to know for proper pizza bones. Fair. Appeals are for losers. We don't want an appeal, but you got to prep for an appeal on this.
So bring the jurors in, please.
All right, we're going to go back to where we were, which was like right at 5 hours. Here we go.
Is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but...
All right, so what is an amicus brief? An amicus brief is basically, it's literally friend of the court, but it's supposed to be like, I have a, sort of interest in this, and, I got to give the doggos treats. I have an interest in this for some reason of, like, this decision affects me, but I'm not actually involved in the case. And amici are supposed to be neutral-ish. They're supposed to sort of advocate for their position as their sort of respective side. So it is very unusual that an expert would be submitting an amicus brief. I think it's highly unusual. So, all right, give me 1 second, because I promised doggo treats, and so we're gonna do doggo treats. And yes, there were 2 different cases. One she allowed in, and that's the one he's cross-examining her about now, the amicus case. The other one was not allowed in, and that was Herrera. That was the one he was arguing about earlier. That's the one he gets shut down on right away. So, yeah. All right, doggos. Puppies. They're learning. Hey, buddy. Hey, buddy. You gonna sit? The treat's in this hand. There you go. Hi, Zora. Come on. Right here. Zora, right here. No, this hand. Come here. There you go. All right, good pups. Good pups. Okay, off you go. The pups are both very eager there. So yes, yeah, he's allowed to talk about this other case, the amicus case. The chair was in the way. Ah, crap. I love how they're always right outside the door, ready to go. They're not. When I called them, they came up there. So, So yeah, they came in there. All right. We might have to do another pup treat because I'm told the chair was blocking things. So
The Friends of the Court, you took a position in that quote Friends of the Court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent.
room
I
is
do
too
not have
small.
that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records. And I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So
she gets very salty here. That said, it is a good answer for Brennan here. So, yeah.
You are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one, which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have,
I want to get a
in
puffer
that
cam.
report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all
He
received
may have been
until about
told
6:04.
he may have been told that he can't. We're going to take it up to 1.25. He may have been told that he's not allowed to ask that specific question. So, yeah.
4 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15.
Page 1529.
The report is.
Would you like the
50
page of the
pages.
report or the page NDA number at the bottom? I can do either
Oh,
way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way
Page
is easy.
7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay.
Let's look at that at one speed where he gets told to slow down.
Interactive phone activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that.
That's the like the court reporter is going, I can't keep up.
I'm just trying to move it along, but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And then if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no, I'm sorry.
Yes.
There is
is one of those really problematic words for a transcript, because when you say on a transcript, it renders equally as versus Those things are the same on the transcript. So, yeah. Good morning from Finland. I want to visit Finland so bad. So, yeah.
no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
Can you answer that? Uzai, can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39. And it will be, thank you. And if we could go to slide 82, please. And
So, there's a company that makes a camera that has like two-way audio and a what is it? And it can rotate, and also has like a button to throw a treat. I keep thinking I should get one. I've got it on my Amazon wish list, but I'm thinking I should get one, and then I could set it up so I could just like add a camera of the doggos and then throw the throw treats. Yeah, it's the Furbo. Throw treats to the dogs on a stream. So I feel like I need that.
Tide, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is
the baby cameras don't usually have the treat throw function.
the 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red. And this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us. He said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. You know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with a device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
She's like, yeah, it might have been a good idea to check that, but no, I didn't do the job. Yeah, okay. He's like, well, Whiffen has this this locked with with button thing. So
Understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that
So at this point, you can see her tone starting to change. She is now really getting condescending. She's getting snippy. She does not like being cross-examined. She does not like any of this, right? So she's pissed.
statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect.
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated that there.
Watch her reaction to this.
You have no basis to contest what.
Oh my God, look at her face. Okay, like she's making the she's making some real stink eye there, right? So she's making some real like she's got some feelings, she's got some thoughts, she's got some emotions, and yeah, this is and I'm just gonna say, as a defense lawyer, if you can make the witness you're cross-examining do this, you're not upset. You're feeling pretty good about this. This is where you're happy.
Mr. Whiffen has stated that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was.
Somebody says, "Can we see that again?" You bet we can.
To contest what. But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is...
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed.
I didn't do my homework.
And I did not, that is not my report, that's Mr. Whiffen's report. So I cannot speak to that without going back and reviewing that evidence.
Isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
Did you catch that too? Her little, she's got a little pissy gesture that she makes.
When you wrote this report?
Yes.
Thank you.
Look at what she does with her face.
When you wrote this report?
Yes.
Thank you.
The little... Okay.
If you could please turn to...
Yeah, we're going to continue on.
In the same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder.
I don't
in
hate
that.
this
And you can
witness.
now
I just
go
don't
to
think
the
she's super
conclusion,
effective.
which is your page 50.
Or at least she could be a lot more effective.
Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis?
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, turn to...
She does not like any of this.
Page 1535 of the same report.
Can you give me my page number, please?
I will.
Okay, thank you.
You're welcome.
Oof.
Can you give me my page number, please?
I will.
Okay, thank you.
You're welcome.
She does the thank you in the most, condescending kind of somebody's got to be like, you got to dial the tone back. Like, you've got to.
If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12/31/56 which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Well, hold on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you.
This is where you get, this is, so I saw people saying that Alessi was shouty. I don't think he's super shouty, but he does keep a pressure on in his, you know, in his cross. And the reason why he does it is for this. This is why he's keeping the pressure on. Like, watch this exchange.
Time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Well, hold on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you.
He's like, you are not going to get to just make your speeches. You're not going to get to speechify. You're not going to get to ramble. You're not going to get to whatever. He's like, I am in control on this one. And I think this is critical with this witness, where he's like, nope, stop right there. Wait for the question, because she will go on and do like a 20-minute, you know, pizza cafeteria example. And you can't have that, right? So Alessi, and the thing is you actually see Jackson fail at this sometimes. Jackson at times, like if you remember Jen McCabe gets away from him a couple of times. Jen McCabe like gets some shots in that he should have tried to shut down. Alessi is keeping better control. And part of it is that this witness is Jen McCabe was better at Jen McCabe is like good at getting the shots in real quick. She's rambly. So she's a little easier to control too, is the other thing. But you've got to actually do it. So, yeah.
So it's got health steps, and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you...
He's baiting her. Did I read that correctly? And she's like, that is absolutely correct. He's like, he's letting her be snarky at, at him there. So, yeah.
Look at this data point in your report on page 13. The steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your
watch this little exchange again. This is Alessi keeping control. Watch.
Later at 12:32:16. Is that correct?
That is correct.
So therefore,
that is correct. And you see, she wants to say more, and he's like, nope, we're getting in here. Like, he's like, that is correct, but I want to, and he's like, no, on to the next thing, right? He's not letting her start in on this rambling, thing. He's like, we're just going to pin you down. Like, no.
Your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there.
And she keeps like, she's trying to butt in. And he's like, nope.
Is that the steps, the mobile phone is used with activity, including steps until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view.
Anytime a witness has to say this is a point where you're losing a little bit. It depends on what your definition of an interaction is. Anytime you have to be arguing definitions of things, you are in the weeds and the jury is moving away from you. So, and my pause game is cruel and unusual, but this is a place where she's kind of flailing a little bit.
view that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand, but
Yes.
the sentence.
So she's saying it's not interactivity because he's not actually pushing buttons and wiggling the joystick and whatever else. And unless he's like, but it shows footsteps, right? It shows steps, it shows movement. And unless he is gaining here because he's getting her to agree that the phone is moving, right? He's pushing that timeline.
Reads include steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m. Correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were stating?
Well, I'll state it again.
I appreciate that.
You're welcome. So, isn't the more correct way to
We're taking this down to 1 speed again, just for.
Just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were stating?
Well, I'll state it again.
I appreciate that.
You're welcome. So, isn't the more
I appreciate that. And he's like, you're welcome. And she's like, I hate you so much. They're getting, they're like throwing some stuff back.
correct way to state this important data point in your conclusion, instead of saying active interaction with the screen in steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation that 12:32 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow
She's like, both are correct. And it's like, he's like, no.
up on this.
Sure.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's not,
if I could just finish,
Please,
because
absolutely,
if we
sorry.
talk over each other.
I don't think she's narcissistic. I don't think that is, yeah. She just doesn't like
The
him.
stenographer's not going to get both of us. Thank
Agreed.
you. So it's not my theory. It's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which, just doing the simple math, is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number. So I center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mhm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
That 191.253 seconds equals 3.2 minutes,
Approximately, yes.
approximately.
I'm doing the math in my head, so that's why I said approximately.
Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone, whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022 for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is for your reports. You don't date your reports, so I can't give you a date, but it says...
It's report 3, I believe, is what...
Exactly.
Yep.
It's 3. And there is... Bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page for
Absolutely.
that time?
I love the Coco there.
I do see an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
I'm just going to say the first trial was basically her direct was confusing. Her cross was confusing. And at the end of her testimony, I came away from her testimony going, I don't know what the fuck happened. This is a little clearer, but she's getting called on things unless he's pulling things out from her that are useful.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no, is that correct? There's no duration yet listed.
Correct.
So
watch again. He's keeping control of this witness. And this is a tough witness to keep control of, but he's doing it expertly.
there is no duration listed for that call. And if you just follow my questions, if you can, yes or no, is that correct? There's no duration yet listed.
Correct.
So what
She wants to give a whole story, and he's like, nope, you're just going to give me a yes or no. And she's like, correct.
I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently. Let me withdraw that. There is no population of the duration column for any call from 14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
yes.
Mr.
Okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So
Look at her face.
8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
yes.
Mr.
Okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So
Absolutely, she says, like she's trying to crap out like a cactus. Yeah, that whew. Wow. Yep.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right. Now what I'd like to do is to turn to the 22740 artifact that was the subject.
Chat, I'm not actually sending anything else, anything out on this goal. It is just a funny goal. Because not all the goals have to be serious or for real. This is a funny goal. We're not actually sending anything, chat. We're not actually sending anything.
Of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp and you would find that parlance acceptable.
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023.
I mean, no, they expect that you've done more than one thing in 2 years. Like, but okay.
You issued a report in
Correct.
May of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct. After being rehired in November.
Right. And you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case. That
And
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that
Look at or watch her facial expression.
On what is the meaning of that timestamp have varied from May of 2023 until today. Have varied from May of 2000.
We just had to get the perfect pause on that one. She's having a good time, folks. She's really loving this. Yeah.
2023 until today. Is that correct?
no, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that
her face doesn't have subtitles? Her face has a freaking town crier. It's got like dudes with like light sticks doing semaphores. Like it's her face has skywriting.
report and your findings were pursuant to a request from Detective Lieutenant Brian Tully.
Correct.
And how many interactions have you had with Lieutenant Detective Brian
Good morning.
Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going
was
to
more
test.
than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp to
When they ask about forensic tools, they don't mean Ian Whiffen.
27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
Fair. Yes.
So you use the words that Google search, "House Long to Die in Cold," was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings.
Now, I mean, most people would be doing a much shorter cross-examination of her, unless he is going through her report and he's gonna just pick at every inconsistency, and he's going to just drag out of her everything she got wrong, and she hates it.
It starts with, there were 2 searches of interest that took place on the iOS device, and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device, right?
Yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
And did you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I've been working on for 2 years is the device.
She is really, and the thing is, if you can get somebody this snippy, it's a good thing.
That was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right. And I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right. So we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay. So
Eastern time for clarity, because
she starts getting into this defensive strategy of getting really particular and really like, I got to be super clear and super exact and super whatever. And it's a technique to sort of bog defense down, but it's an evasive technique. It's what she's doing.
Some of these records.
And she was not that technical and that like nitpicky. She was a little bit nitpicky, but she was not this nitpicky on direct.
Are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly. And that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, a second sentence, a Google search for how long to die cold at approximately 11:23 a.m. And then House long TI, DIE, and cold took place at 11:24.
That is in UTC. I apologize for not having the timestamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
Correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now,
Perfect.
but in this report, there is no UTC time down. You have two additional times in addition to the two times, two different numbers added to the two, correct?
The UTC was a typo. It should say UTC next to those, and the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So
she's like, yeah, my timestamps were bad. That's not a big goal there. So yeah.
in terms of your May 2023 report, your first report in this matter,
Yes.
you on page 5,
Mhm.
in the sentence underneath the block paragraph state, in the instance of the Google search, house long to die in cold that was recovered from the write-ahead log associated with
That's correct.
the X browser state with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to
I have a little
page 7
scotch.
of your report,
I poured a little scotch.
Mhm.
up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency
Mhm.
with timestamps parsed from this file.
This is fun.
It is, however, definitive that the page existed in a tab.
Correct.
He's going to get a really good admission out of this.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown,
Mhm.
the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So is of
Did I read that correctly? You did read that correctly. You're not winning here, Ms. Hyde.
May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry. I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is a time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on.
We're going to jump ahead just a little bit, but oof, that's a bad admission there.
Fact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read that correctly?
You did.
She keeps doing this as it's not helping her.
Lots of things. Did I read that correctly?
You did.
Oh, Christ. Okay.
Not one thing. You said it could be lots of things, correct?
That is correct.
And then you go on in line 10 and you talk more, and then you go down to the bottom. You go down to line 20 and you testify, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that in browser state DB. That does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
Mm-hmm.
He's moving her
If you
away
go
from
to
her
page
defensive explanation.
129 of this transcript.
I'm there.
At the top,
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember, we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn to page.
Oh, look at this.
Entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn.
Ooh. You read 100% correctly, and then she looks over to the jury for approval.
Turn to page 130 of your testimony.
I need to object.
I'll see you.
Then she looks over to the jury for that approval. Okay, we're gonna skip ahead a wee bit.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages. And bear with me. I think this
No
may
problem.
be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database. It was in the write-ahead log. And to Cellebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number 1?
You read it correctly.
So am I correct that here, what you're stating is Cellebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
On
proceeding?
that date, that is correct.
Okay,
Yes.
so I just wanted to establish that, and you were
Absolutely.
giving Cellebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Cellebrite and Magnet Axiom,
Mhm.
and then you elaborate, both Cellebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Cellebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read
That is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur that you use the words associated with a Safari Google search, house long to die in the cold.
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question.
That'd be great.
He's like, nope, we're not letting you go. We're not letting you do that. No.
More simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. All right, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have
have
the
it correct.
chronology correct, Ms.
That
Hyde?
is correct.
So in December of 2024, just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
We're going to
Correct.
talk about
2740.
we're going to talk about my final assessment on her. So yeah.
Timestamp. And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a year and a half. Is that approximately from your May 23rd report? Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
I don't have a timestamp for this, but I also entirely disagree that that's what happened. So we'll have to see what's there.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, Magnet Forensic Axiom showed up, that was removed by Celebrite, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it. Yeah.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics.
That is correct.
Still shows that timestamp.
Yes,
right?
yes,
But Celebrite doesn't in the
that
automated
is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the time?
We'll skip by a little bit here. We'll go to here.
Information about when a search occurred, what it's associated with. Wouldn't the best information be in the Apple source code to answer that question?
Is that for the?
It is acceptable in digital forensic science and in
Is that for
accordance
the- I'm
with the
sorry?
NIST Science Foundation papers to conduct
right.
testing to determine how the functionality of something works.
My-
You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place to go is to the Apple source codes themselves? Or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, those are incongruent statements. Apple source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation. We don't know the length.
Oh, it would be so onerous. So it would be a lot of work, you're saying. This is actually really interesting because I'm like, this is bullshit. The only reason you're not using the source code to look at this is because Apple doesn't release the source code. It's proprietary. They're not giving it to anybody. So, yeah.
Which that is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works.
So she is salty about this case that she lost. And they're like, we're just trying to see if they can get it in there. But yeah.
Through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way.
If I'm him, I'm like, we should get this in.
I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever learned of, have you ever spoken with Mr. Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just
I have not had that conversation with Mr. Whiffen, no.
Okay, all right. I want to move on to, and do you regard Mr. Whiffen is a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
Sorry, we have to wait for each other.
Oh, yes, I'm sorry.
It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the HistoryDB database. You are familiar with HistoryDB? HistoryDB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the HistoryDB?
In this instance, no, we do not have artifacts in the HistoryDB of either of those two searches.
So I want to just repeat that in a different way. So the HistoryDB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that HistoryDB, do they?
That is correct.
You spoke about PYF PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination.
And I'm going to skip ahead a little bit.
Case if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe.
And yeah, this is the thing, but wouldn't the code be the best option if it were available? And aren't all of your NIST policies best practices based on the fact you don't have the Apple source code available? Yes. And if the Apple source code was available, they could understand better how it is that it does these things, right? How these things could be, could be done. So, yeah. Also, this one is referring to other Ian, not me. I think.
The ideal situation is to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is a document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger, just like when your battery runs low, you plug in a charger in the back of these.
Basically, they're like, she's going, I'm going to relate to the, I'm going to relate to the jury here, but basically they're like, we're going to take a Faraday bag. We're going to attach a charger to the phone. We're going to drop all of that stuff into the phone. Now, here's the other fun thing, which is that iPhones and now Androids have adopted a policy where if you do this to them, they will reboot and go into a before first unlock stage. So you'll hear she at some point, I don't know if I've actually got it on my list of things to cover, but she says it depends on whether it's a BFU or an AFU state. So BFU is before first unlock and AFU is after first unlock. And so basically if the phone has been rebooted or started up before any password is entered, it is in the BFU state. And without going into the technicalities, the BFU state is much, much harder for them to break into than the AFU state. So before first unlock is way harder to break into than the after first unlock.
Battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is and what make and model that device is and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
please.
And I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device. So if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time yet? Yes. Thank you, Your Honor. So bear with me, it's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right. It was at the bottom of my stack. I had to lift up the other ones to find it. All right. So,
Your Honor, may I assist and point her to a page?
Sure. That'd be
Thank
great.
you. If you could turn to that report on your page.
They cannot. The Apple engineers get the Apple engineers will have like the massive NDAs to not disclose any of the source code details, etc. And I see somebody saying, can't you just answer yes or no? No, I got to set a new goal. Cause we got to 2 out of 10 and, yeah. We're going to do another doggo treats goal cause we should. All right, here we go.
47 and continue.
Yeah, NDAs expire too, but these are probably like 15-year NDAs to not discuss the source code.
On to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or Faraday box. That's correct. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me reviewing the data.
It sounds like you're trying to justify.
Oh, I'm not trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct?
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice would be to Faraday. I 100% agree.
My question wasn't, is there more or less data? My question.
He's like, sounds like you're trying to justify it, and she immediately is backpedaling.
Question was simply,
this is at 1 speed now.
Your own report
Sure.
show activity up until noon on January 29, 2022.
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yeah.
There is activity on
Absolutely.
this phone.
Absolutely.
Which shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box. and that failure is not best practice.
Correct. It is not in accordance
Thank
with the best practices. I agree. I would have Faradayed it.
Thank you. So
I would have Faradayed it. And he's like, thank you. And Brennan is like, fuck. Yeah.
If I,
but that's
presuming
that's
all
okay.
things.
I have no.
Yeah, I mean, they probably put it into a Stop and Shop bag, which is as good as a Faraday bag, right?
Further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
Oof. Thank you for your questions. Have a great day. Comes off really, really snippy.
All right, Mr. Brennan, redirect.
Thank you. Of course.
Oh, we are well into spicy time. I suppose it's been a while since I rolled the clip. We can roll the clip.
Whenever you're ready.
Thank you, Mr. Brennan.
You are. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023. May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case,
Okay, I'm going to take that down to 1 speed.
Because May the 4th be with you.
When-
Of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
when you first were asked to begin,
Okay, she's kind of my people because I would totally make that joke too. It's nerdy. Brennan smiles. Brennan makes a little face. The whoever this is, I think she's probably a bailiff. She smiles too. That was really endearing, and it is totally my so yeah. Yeah, it was. I don't think she was like, she's just a geek. That is fair. She's just a geek. That's all. I hate that reference, but only because it's my mother's birthday. It's overdone geekery, but it's still it's minor geekery. So yeah. That originally had nothing to do with Star Wars. It came from British politics. Okay. It's just, whatever. My son bought a $300 lightsaber with his adult money last week, hoping it would get here by the 4th. It got here today. Oof. Ouch. I don't have an issue with that. Yeah. So, all right. So, yeah. All right. Let's, where do I want to go? I don't really want to cover a lot of the redirect because the redirect I thought was kind of boring and not super useful. Let's go to the moment people were wanting to talk about. I've got a very different impression of this moment, so we're just going to talk about this?
Dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag. So usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But
oh, the timestamp is not timestamping. So the timestamp apparently was not correct for the thing.
no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the
Yeah, this is dark, but this is actually fairly common. If you've got a dead person, you might need to actually use their thumb to open it. And they say you can't open a Faraday bag. The thing is you're not supposed to open a Faraday bag because the instant you open a Faraday bag, what does the phone do? The phone reconnects to the network. And so, for example, let's say that I'm the drug dealer from the example before, right? So, and as soon as I get arrested, I send a signal to the phone to say, destroy the phone, right? I send a wipe phone signal to the phone. If they open the Faraday bag, then the phone connects to the network, receives that pending wipe phone signal, and then goes and says, okay, I'm going to wipe. And then there goes the phone. So you keep it in the Faraday bag because the instant you open it, it might get that wipe signal, and that's it. So, yeah.
opinion that this item was not placed in a Faraday bag at 6:04 in the morning. Does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about history DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in history DB. That isolated question, does that provide any context?
Dealers are usually not using any sort of security. Dealers are usually just using the text app, and yeah.
You and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning.
The absence of the history DB artifact doesn't mean that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari plist, which tracks the history, as well as the Knowledge C DB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the Knowledge C and the Mobile Safari plist.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data for January 29, 2022,
That is correct.
page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps, it could be you're carrying it, it could be that you're in some other kind of motion, you could be on a bicycle, you could, any number of things. And the number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other
I
things
have
to
one,
cause
but I don't
steps
know
to
where it is
occur.
right now.
You were asked specifically if you
I've
saw
lost
that
the
there
pickle.
were
I didn't hide the
reported
pickle. I just lost the pickle.
movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of
All right, so I'm seeing 627.50 maybe. We'll try that.
regarding Mr. O'Keefe's phone.
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about history DB, and it was simply whether or not How's long.
No, it's not at
to die in
627.50
cold,
either.
whether it appeared in history DB. That isolated question, does that provide?
All right, so I can't find the timestamp, and I'm getting I'm getting sort of inaccurate things on the timestamp, and it's probably because somebody's looking at the wrong thing. But so there's a moment that is going around on Twitter. And the moment, let me see, maybe I can just find it on Twitter and pull it up. Maybe I could do that, because there's a moment that's going around on Twitter, and lots of people have opinions about it, and I also have opinions about it, but I kind of feel like most of the opinions are wrong. So we're going to have a look at this one, because I think that I think a lot of people are jumping at shadows here, and I think it undermines the overall. I think it kind of undermines people's takes when they do that. So I'm just trying to find this bit here. And it looks like it's a clip from Emily, but so you're just going to see Emily in the corner, but we're not actually going to hear her because she doesn't talk in this one. But here we go. This is the clip. And I'm kind of over top of Emily, but it is what it is. So we're just going to like see this little thing here and see what, what's going on there.
For the phone of Mr. O'Keefe, can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Sorry.
And that.
So the thing was, people say, like, people are going, she says sorry, and they're saying it's a sorry to to Hank Brennan. And no, let's hear it again.
Okay.
Sorry.
Do you hear the bump? Do you hear the bump?
To put it in a Faraday bag.
Okay.
Sorry.
And that phone was obviously.
I think she just bumps something and she apologizes. That's all I get, right? I think she just like bumps something and goes sorry. Right? It's just like, I don't think that was some secret communication. I think that was just, I nudged a thing and whoops, my bad. So I see like a lot of people on Twitter are making like this is some conspiracy. And I got to play the thing because I just said conspiracy.
Conspiracy.
I don't think it's anything. I think that's nothing. That's my take on that. Is it's nothing. So, yeah, I don't see it. I don't see it at all. So, All right. Let's keep going here. We got a little bit more to cover. We're gonna jump to basically the end of things, and talk about. Well, we're gonna talk about her testimony. I actually thought she did all right. I thought she was actually kind of bad for the defense, but not as bad as she could be. She could have been devastating to the defense. She could have been really, really damaging. And the thing is that a lot of it was buried. A lot of it was buried in, like confusing testimony, in stuff that she could get, dinged on cross-examination, on her copying an excessive amount of attitude. The thing is ultimately at the end of it, I actually found her explanation credible. And I actually thought she did the work on it. And I know that's going to piss a lot of people off, but I actually did. I just thought that she was also really bad at communicating it. Like really, really bad at communicating it, to the point where jurors may rule it out on the basis of that she was too snarky, that she was too confusing, that they were too lost on it, that they were too whatever. But at the end of the day, the defense got a really good appeal issue out of this. So, I don't know. I mean, we're going to have to see. The thing about the search is that the search is make or break for the defense in one way. In the sense that the defense, if the defense establishes that search was made at 2:27, it's game over, right? That's the end of it. However, if that search was made at 6, then I don't really see that it's a huge issue on that one, because at the end of the day, it's like, okay, then she's just, asking because she's worried, right? Now the prosecution tries to make this make or break for the defense as well. And we're going to look at that. And I think that this is actually really awful for how the judge is letting them use these clips. I think this is really awful for the way the judge is actually allowing these clips to be used basically as argument rather than evidence. And I think that these videos should have to be played as a video, not as clips, because the playing it as clips basically just works out to argument. I mean, I think that this witness is too much of a know-it-all. I think this witness is too confusing. But I genuinely think this witness was trying to tell the truth. And I think that this witness was actually pretty knowledgeable. So we'll see. But yeah, the clips. Let's go to the clip they run at the end here. Here's the clip they run at the end.
Yes.
I would like to play clip 15, please.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
That's not even a complete sentence. I'm like, what is the what is the thing? What is the complete sentence there? Like, they should have to have a little bit more context. But basically, that video is either, Jen McCabe, either I'm going down or she is. So basically, the Commonwealth's argument here is that this whole thing is just they're trying to frame up Jen McCabe so that she doesn't go down. And I'm like, So that's really what they're looking at here. So that was today. That's kind of the end of the day there. How do you cross-examine a clip? Lawyer you know thought that this actually pointed the finger at Jen. It might. The thing is we don't know what's in the jurors' heads right now. Because if the jury right now is thinking that Jen McCabe is a villain, and I don't know if they are, if the jury is thinking that Jen McCabe is a villain, then they're probably like, yeah, she's realized that she has to, that she's got to, that it's, she's got to take down the person framing her or else, right? That's kind of the thing, right? If somebody's trying to frame you, one of you is going to have a bad day. So, I mean, I don't know, right? I don't know. We'll have to see on that one. It's going to be interesting. And keep in mind, we are partway through the trial. People are like, what would you do at this point? And I'm like, at this point, they haven't actually conclusively proved that John O'Keefe is, well, I guess they proved that he's dead, but they haven't proved that he was hit by a car. They haven't proved that he was hit by, Karen Reed's car. So at this point, people are like, if the trial ended now, I'm like, if the trial ended now, they haven't established their case at all. They're still building their case, and then the defense is going to call their witnesses. But, so we'll have to see. All right, let's go through super chats, and then that's pretty much today. And then we will, establish that. I don't think they've proved he's dead yet. They did have witnesses that found him dead. So, I think that they could establish that he was dead. I don't think that they could necessarily establish that he was murdered. Yeah. All right, let's keep going here. What is it? Jerf says, priming the super pump. Thank you, Jerf. Steve Kate, Kate, thank you very much for greatness and time. Thank you so much. Cheryl Reed, nerdy day, but also very boring. Not too bad for Karen Reed. I thought the prosecution moved their case ahead, but not as bad. Yes, we talked about May the 4th. Can the defense play the interviewer questions for completeness? They could play the whole video, in theory. They could insist that the whole video be played. I think that the whole video should have been played rather than those clips out of context. And if I was the judge, I would say, no, you could play the video. You just can't use the video as these little argumentative snapshots, right? So, yeah, it doesn't make sense. So, noodles with extra slurps. We're not doing that. Laura Christine, dinner fund. Thank you. Jen loves wine. I'm glad I wasn't the only one who found today confusing, but I did enjoy some of the exchanges. Hyde had some edge to her answers. She did. She gets a little snippy. Red, thank you for the new membership. Much appreciated. Lita Randolph, does he sit at a desk until there's a crime? I suspect he does other, things as well. If there's nothing else for him to do, they might put him on patrol. Might put him on patrol. Yeah. Horse welfare. Thanks for having some knowledge about the proper donning and doffing of PPE to prevent contamination. Your snark always brightens my day. Thank you. Tough cookie. So can we have a poll to decide what Runkle, or so we can have a poll to decide what Runkle has for dinner? You guys decided burritos. It was a good decision. Brentwood Cheek, chicken, burger, or pizza? Well, it ended up being neither. Laura Christine, only once we clear the goal. Cad Monkey FPV, the nurses drawing my blood aren't using solo cups. Should I be worried? Laughing face. I missed all the trial today, so really needing today's recap. Surgery. I hope that went well, Cad Monkey. To Cadmiral Tech Admiral Call, I guess. Tech Admiral Call. Okay. Kind of hard to hide the guy who ran the entire investigation badly. They're doing their best. Melissa K. Hank's only goal is to muddy the waters for what the defense is going to say and get the lesser manslaughter charge to stick. That'll be a win for him. That's why he's trying the case this way. And he knows that if he gets the manslaughter, she's going to sentence him to, or sorry, she's Judge Cannone's going to sentence Karen Reed to like 20 years. So yeah. Dylan the Uprocker Schultz. Carl Jobs lost his lawsuit and is being accused of misrepresenting the lawsuit to obtain funding. Also, like you, Billy Mitchell sells hot sauce. I might have to try one of his hot sauces just to find out, just to see on that. I see we got 240 for one more super chat for the pupper goal. So, yeah. I just saw a chat that I wanted to cover there. Runkle, my son was born at Grey Nuns yesterday morning, 1 month early, and with the cord wrapped 5 times around his neck. He's a miracle. Shout out to the doctors and nurses at Grey Nuns. Shout out indeed. That is amazing. I hope everything's all right, but it sounds like it is. So, yeah. Michigan Farm Boy. Andrea said the rule the judge used is about interpretation when a rule statute is unclear. Correct. On its face. The rule Alessi cited was clear. Absolutely it was. Shall. Andrea thought this would be an appeal point to preclude challenged credibility. I agree. Mostly harmless fuzzball. Hank's concerned about maligning Hyde, the way he did Russell and Arca and tried to do to Green. Yep. The ghost of Brian Higgins' SIM card. I could be wrong, but I thought she testified that 1, a search for Haas Long happened at 6:24, which defense doesn't deny, and 2, she cannot be sure what was searched at 2:27. 3, she did not delete the search. I'm okay. Am I wrong? She testified that no search happened at 2:27, I think is where she was coming in. Mispronounced name. Make Bob guilty again. Excuse me. So appellate issue? I think appellate issue for sure. Cheryl P., thank you for the super sticker. Much appreciated. Mama Betts, happy to hear you call out the BS. It's a whole thing. And Belle Feinstein, emergency plan for zombies. Make popcorn and watch the movie. Tori Amethyst, Runkle's outrage is a great birthday gift. Happy birthday. I see there's a lot of birthdays in the chat. I see people saying it's Emily's birthday. So happy birthday, Emily, as well. Happy birthday to everybody. So, yeah. All right. Brain's attorney at law would like a word about the zombies are going to happen. Law Nerd Amber, rant away, Runkle. I had a rant. Joy W for the anger against all the unshalls. The ghost of Brian Higgins' SIM card. She could have alopecia too. Be nice. I am not going to throw shit for... I assume it's religious. I don't know, and it's none of my business, and it doesn't matter to her testimony. Daddy needs a drink. I did indeed. Law Nerd Amber, smoking a nickel and sending a nickel. Lol. KPT, join me in a birthday drink. Happy birthday, KPT. Happy birthday indeed. Heart to be here with y'all. Chat here is fabulous. Happy birthday. Jedi Jen. So according to her, the 75 tabs I've had open since 2021 haven't stored timestamps since they're still open. Sure. And I have some oceanfront property in Arizona to sell to you. I'm wondering, does this blow up a ton of other cases? So Billy's Momzilla, how will the Commonwealth's denial disapproving of the 227 text affect other cases that have used text timestamps as evidence? Could cases be reopened? They won't be. GP Dog Drool, she knows more than everybody. Great summary. Drink well deserved. Thank you. The other Jules, do you think the jury is wondering why so many experts are being brought in to debate Jen's 227 Google search? I'm sure that the jury has figured out that if that search happened, then Karen Reed is innocent, right? 100%. So mispronounced name, all the cell experts and experts we've heard from have successfully convinced me that Apple's cell phone data isn't reliable. Michigan Farm Boy, I think Alessi thought or hoped that Bev only kept the evidence out and hadn't blocked the cross, also for the goal. I think he just did it for the appeal. I think he put that in to record up his appeal. Fred of Orange's court cam. Do you know when the laws changed in Canada about jurors talking about cases? I don't exactly. I'd have to look it up. I recently saw a multi-part series about the Bernardo Homolka case, which included an interview with one of the jurors. That juror would still be breaking the law because it doesn't allow for interviews. Annika, leaving for work, not because of rant. Love rant. Thank you. Cad Monkey says, Potter and Zora deserve the treatiest of treats. I think we hit another treat goal. So, Michigan Farm Boy. Andrea also commented on how she gave a curative instruction and then made excuses for it. Totally inadequate. It was a shitty curative. Michigan Farm Boy, they're wasting time because I won't let them do their job. Jerf, the whole trial in 5 words. If Canton can't, Cannone can. Law Nerd Amber. Solidarity is an ADHDer with back pain. It's a whole feeling. Ann Bell Feinstein. This expert would have had me daydreaming by now or writing an unrelated short story in my notebook. I feel like there was probably some of that. Gen X Gamer Girl. My husband wants to know what the gun in the picture is in the picture behind you. I figured it out at one point, and now I can't remember. I don't remember what the gun is, so I will have to look that up. Honk Brennan's favorite forensic homeopath. I liked her analogy at first, but she kept it running too long. I would have wanted her to stop using the hypo after the very first illustration. It could have been a good analogy if she'd kept it short and not gotten complicated and weedy about it. And I say that knowing the irony. Grilled cheese, doggos. Thank you. Ms. Monty, thank you so much. Michigan Farm Boy, Schrodinger's wall file. It has both food and has deleted food until restarted. Billy's Momzilla, 227. Hoss Long is texted, but internet slows and response delayed until after 6 a.m. Maybe, I don't know. Sergeant Bukaki's tainted evidence, 45 minutes behind, but I have 1,600 open tabs. They're in groups, but yeah, I nearly had a panic attack when I upgraded my phone and only 600 came over. That is too many open tabs. You got to fix that. Shay B, Alessi is pretty stonewalled with her. Alessi actually does really well with her. Alessi actually did a fair bit there. Steve Powers, okay, serious question or serious debate question. What toppings belong in a pizza? Need to know for proper pizza bones. Anchovies, olives, and I'm getting people going, Runkle, no. Cielo, doggo. Angie, funds for the Furbo. I purchased the Furbo. It says it'll be here Friday, which probably means it'll be here Monday. So, yeah. Sergeant Bukaki's tainted evidence. JFC, Bev, have you ever heard of a soap party? Well, we're not talking that. If not, well, those just no, we're just not reading the rest of that. We're not going to talk about violence towards the judge. That's not happening. Nancy Druby, I'm absolutely in for the camera for the pups. I have ordered that. Jennifer, the dog lover, for the pups and the Furbo. Thank you. Lonely Lark, Furbo Fund. Thank you. Michigan Farm Boy, there was a lot of out nicing each other between Alessi and Hyde. The lock button expression was not a thank you back to Alessi. More F you than thank you. Apocalypse DOA, the judge enabled Jen McCabe a lot, though. Yep. Steve Powers, what if any definition is interaction? Forgotten Tupperware, you twisted my rubber arm. That was for the scotch, and the scotch was delicious. Alessi's word a day TP. I love going through testimony with the Ruggleisms. It's the best. Thank you guys so much. The other Jules, Recovery Addicts chat was having so much fun with her. You did. That is correct answers today. She's got a style. We'll go with that. GV, objection, dehumanizing. Sin N. Until January 2023, Apple released Darwin as open source BSD Unix variant. It still releases several parts of the OS, but they dropped the Darwin name. Might have been controversial. The other Jules, doggo treats. We'll arrange some for the dogs. And other under your scars, puppy power, lol. Thanks, Ian from Ontario. She should get screenshots of all her pics from here for a collage, lol. Cat's pajamas, doggo treats. Thank you. Southern Mom, it seems like some witnesses have not been instructed about not mentioning the first trial. That has sailed. That ship has sailed. It has caught fire. It has exploded. It has sunk to the bottom of the ocean. It has exploded again. It has somehow sunk even lower than the bottom of the ocean, exploded a third time, and it's gone, right? So, and Ms. Hyde needs guidance on her testifying behavior. She does kind of need you should dial this back. Colin, speech therapist, thank you. Bex, this is my first live with you, and for the spice, I have to send this. Thanks, Ruckle. Spice in the fourth in the 2 minutes. Win this evening for sure. Thank you so much, Bex. Michigan Farm Boy, you wouldn't open it until you could do it in a Faraday cage, so it would still be protected. Yes. If you opened it in a Faraday cage, you're fine. The other Jules, hello, doggos. We'll do the doggos shortly. Josh H, the Commonwealth timeline doesn't fit. They claim he was hit at 12:31. He accessed his phone at 12:32. Karen Reed was at his house at 12:36, 2.3 miles away. So either she's driving really fast in the snow, or it doesn't make sense. Lauren Boborin, Karen Reed says they're playing the full vids in their case. That makes sense. Rob Price for the doggos. Thank you. Lauren Boborin said it to Court TV or Law in Court outside court today. It would make sense to me. Ashley Lauren, thank you so much. Dean Hernandez, catch a recaps at night and enjoying everyone. More treats for the puppies. And I'll move the chair properly this time. This trial better end some careers and not in retirement. It already has. It's ended Proctor's. Michigan Farm Boy, is Billy Mitchell's cuz donkey sauce or his hot sauce, is it called donkey sauce? I don't know. Lissy Quinn, if Jen McCabe opened the tab, typed the question, minimized it, then returned later, doesn't that still show prior knowledge of John's death and make her potentially culpable? They were saying that she opened the tab to search Hockomock Sports. Wouldn't the initial tab opening trump the last? They're saying that the initial tab opening was for Hockomock Sports, and then later Salty C, maybe make a poll once a month regarding a dinner item so we can all partake together. That's kind of a fun idea. Josh H, Bev created the sidebar issue by denying speaking objections. She can't get mad now. And in fact, they specifically said, Judge, if you don't allow the sidebars, then there's going to be a lot of delay. There's going to be a lot of all of this. And so they said, like, Judge, there's going to be a lot of slowdown if you don't allow us to go objection hearsay. And she's like, that sounds like a you problem. And it's like, nope, that's actually an everybody problem. So, yeah. Nunk says, I think a lot of the hate towards Hyde is based on looks. I don't like the judging on looks. She does have an odd appearance, but who cares? She knows far more about SQLite than commenters who heard SQLite for the first time today. I can say I didn't hear SQLite for the first time today, but she certainly knows more about it than me. It's just a question of whether or not she's delivering it appropriately. I do actually think that she knows what she's talking about, and she did convince me. I don't think that search happened at 227, but I don't think it matters to the case, if that makes sense. Oh, and before I go feed the pups, I got to roll this. And AJZ says, thanks for the reliable and essential daily recaps. Much appreciated. Thank you so much. I have the secret lab chair. The neck pillow on your back is so much better. Maybe I should try that. All right, let's feed some doggos some treats. And all right, chair is way out of the way. Okay. All right. Chair out of the way. Okay, good. We're good. Puppies. I got treats. Potter might say, screw this, because he's sleeping. Stop with the chair. Chair, you got to not chair. Yeah. Potter. Okay, so Potter has opted out. He's like, I'm sleeping. I don't get up for this. Chair, you got to stop moving. All right. Oh no, here he is. Hey, Potter. You want a treat? Potter is now being camera shy. Zora. Here you go. Potter, come here. Potter, you got to come here because this chair keeps wanting to block things. Come here, boy. Oh, Potter wants to lure me out. Here, Potter. So Potter is being camera shy because Potter wants to lead me to the back door because he thinks that 11 at night is a great time to run around and play in the backyard. And he's not wrong. I will probably play with the I'll probably play with him in the backyard shortly. But no, Potter doesn't want me to go to bed. Potter wants me to run around. So Potter wants a bit of like playtime. So yeah. All right. I think that wraps up day 11 of the of this trial. So I'll see you tomorrow for day 12. Good night, everybody.